Just a reminder, we'll be finishing Tractate Shevuot very shortly, but we're going to be saving the very last section of the last daf for Sunday. We're going to have a siyum. So if you're local to Ava, Missouri, if you're in southern Missouri and you want to join us, we will be finishing up the tractate on Sunday, June 22nd. So you can get in touch with me if you want to join in. But anyway, we're at daf 47, but tonight we're going to study this for the Ilui Nishmat of Fransisco Orellana, who passed away recently. So here we go. At the end of 46, it says the Gemara raises a difficulty. It works out well to make a distinction for one who is liable for an oath on an utterance like "I will eat" or "I will not eat," where it is possible that he was not lying when he took the oath. But with regard to oaths about the past, like "I ate" or "I did not eat," what can be said, since he certainly took a false oath? The Gemara answers, teach the Mishnah, or meaning understand it to mean, an oath taken in vain, or any oath that is similar to it, that is clearly a falsehood, disqualifies one from further oath-taking. So the Mishnah teaches, if one of the litigants was a dice player, or one who lends with interest, or among those who fly pigeons, or among the vendors of produce that grew during the sabbatical year, then the litigant opposing him takes an oath and receives payment of his claim. The Gemara asks, why do I need these additional examples of a person who is suspect with regard to oath-taking? The Gemara explains the Mishnah first teaches examples of people who are disqualified by Torah law and then teaches examples of those who are disqualified by rabbinic law. The Mishnah teaches if both litigants were suspect, the oath returned to its place. This is the statement of Rabbi Yoshi. Rabbi Meir says, since neither can take an oath, they divide the disputed amount. So Rava said to Rav Nachman, how is it actually taught? What is Rabbi Yoshi's opinion and what is Rabbi Meir's opinion? Rav Nachman said to him, I do not know. Rava answered him, or asked him, what is the halacha? And Rav Nachman said to him, I do not know. Okay, it was stated that Rav Yosef Bar Ben Yomi said that Rav Nachman says that Rabbi Yoshi says they divide the disputed amount, and similarly Rav Zavid Bar Oshaya teaches that Rabbi Yoshi says they divide the disputed amount. The Gemara records a slightly different version of this tradition. There are those who say that Rav Zavid teaches that Rabbi Oshaya says that Rabbi Yoshi says they divide the disputed amount, and Rav Yosef Bar Minyumi said that Rav Nachman ruled in an actual case that the litigants divide the disputed amount. So Rabbi Yoshi rules in the Mishnah that in a case where both sides are suspect and cannot take an oath, the oath returned to its place. The Gemara asks, to where did it return? What is meant by the oath returning to its place? Rabbi Ami said that our sages in Babylonia say, the oath returned to Sinai, where God administered an oath to the Jewish people that they would keep the mitzvot of the Torah, including the prohibition against robbery. The litigant who is robbing the other will be punished by God, not the court. Our sages in Eretz Yisrael said, the oath returned to the one who was initially liable to take it, that is the defendant, and since he is disqualified from taking an oath, he must pay. Rav Papa said that the term our sages in Babylonia refers to Rav and Shemuel, and the term our sages in Eretz Yisrael refers to Rabbi Abba. The fact that the term our sages in Babylonia refers to Rav and Shemuel is, as we learned in a Mishnah, so 45a, and likewise orphans can collect a loan with a promissory note inherited from their father only by taking an oath, and we discussed it, upcoming 48a, asking from whom do they collect a debt by taking an oath? If we say that they collect this way from the borrower, that is, those who borrowed from their fathers, that would not make sense. Their father would take payment with the promissory note without taking an oath, and they collect only by means of taking an oath. Don't orphans have privileged status? Rather, this is what the Mishnah is saying. And even orphans do not collect with their father's promissory note from the borrower's orphans, except by means of taking an oath. So Rav Papa continues. And Rav and Shmuel both say that the sages taught that the lender's orphans need to take an oath in order to be paid by the borrower's orphans only when the lender died during the lifetime of the borrower, and the lender's children have an opportunity to collect directly from the borrower without taking an oath. But if the borrower died during the lifetime of the lender has already become liable to take an oath to the children of the borrower, since one can collect from orphans only by means of an oath, and a person cannot bequeath an oath. That is a debt that requires the taking of an oath in order to be collected to his children, and no payment is made. The lender's children cannot take the oath that their father would have taken, that the promissory note has not been paid. The only oath they can take is that their father never told them that it had been paid, and that is insufficient once the father became liable to take an oath. From here it is clear that Rav and Shmuel hold that when no oath can be taken, the oath returns to Sinai and the court takes no action. The fact that the term our sages in Eretz Yisrael refers to Rabbi Abba is as the following story illustrates. As there was a certain man who snatched a piece of cast metal from another. The one from whom it was taken came before Rav Ami, while Rabbi Abba was sitting before him, and he brought one witness who testified that the other man did in fact snatch it from him. The one who snatched it said to him, "Yes, it is true that I snatched it, but I merely snatched that which was mine." Rabbi Ami said, Rabbi Ami said, "How should judges rule in this case? If they were to say, the one who snatched the metal, go pay for it, that would not be the correct ruling, because there are not two witnesses who saw him snatch it, and the court does not force payment based on the testimony of one witness. If they were to accept his claim and exempt him entirely, that would not be the correct ruling, because there's one witness who testified against him. If they were to say to him, go take an oath, which is the usual response to counter the testimony of one witness, once he said that he did in fact snatch it, and there is no proof that it is his, he is like a robber, and the court does not allow a robber to take an oath." So Rabbi Abba said to him, "He is one who is liable to take an oath, who is unable to take an oath, and anyone who is liable to take an oath, who is unable to take an oath, is liable to pay." This illustrates that Rabbi Abba holds that the oath returns to its place, that is, to the defendant who is disqualified from taking oaths, and that consequently he must pay. So Rava said it stands to reason that the halacha is in accordance with the opinion of Rabbi Abba, as Rabbi Ami teaches this baraita. The verse states, "The oath of the Lord shall be between them both," Exodus 22, verse 10, "but not between their heirs." What are the circumstances in which one may be liable to take an oath, but his heirs would be exempt? If we say that it is where the lender's son said to the borrower's son, 100 dinars that belong to my father were in the possession of your father as a loan, and you must repay me. And the borrower's son said to him he had a debt of 50, and the other 50 he did not have to pay him. That is, he did not owe it. That is difficult. Under these circumstances, what does it matter to me if it is he, the borrower's heir, or his father, the original borrower, since the son is admitting that he owes part of the money and denying the rest with certainty? He's liable to take an oath just like his father would have been. Rather, is it not that the lender's son said to the borrower's son, 100 dinars that were my father's were left in the possession of your father, and you must repay me? And the borrower's son said to him, concerning 50 dinars, I know that my father owed them, but I do not know anything about the other 50 dinars. So Rabbah continues, granted, if you say that his father, in a case like this, would be liable to take an oath due to his partial admission, then the verse was necessary to exempt the heirs from taking the oath. But if you say that in a case like this, his father is also exempt from taking an oath, why do I need a verse about exempting the heirs? Evidently, an oath reverts to one who is liable to take it, and when he cannot take that oath, he must pay the claim against him. The Gemara asks, and for Rav and Shmuel, who hold that one who cannot take an oath does not have to pay, and therefore there's no difference between the heirs and the father, why do they derive from this verse, quote, the oath of the Lord shall be between them both, Exodus 22, verse 10. The Gemara answers, it is necessary for that which is taught in a Braita. Shimon ben Tarfon says the verse, quote, the oath of the Lord shall be between them both, teaches that when one litigant imposes an oath upon the other and he takes a false oath, the oath applies to them both. That is, they are both held responsible for the desecration of God's name. Since this sage was mentioned, the Gemara cites some of his other statements. So Rabbi Shimon ben Tarfon says, with regard to the prohibition of following after an idolater, so Adulterer, providing him with assistance in carrying out adultery, from where is it derived? The verse states, you shall not commit adultery, lo tinaf, Exodus 20, verse 13. If the verse is vocalized slightly differently, it may be read, you shall not cause adultery, lo tanif, instead of lo tinaf, lo tanif. Commenting on the verse, describing the verse of the Jewish people to the spies, slander of Eretz Yisrael, and you murmured in your tents and said, because the Lord hated us, he has brought us forth out of the land of Egypt to deliver us into the hand of the Amorites to destroy us. Deuteronomy 1:27. Shmuel ben Tarfon says, teragenu is interpreted as though it is composed of two Hebrew expressions. In teragenu, that is, and you murmured. Okay, so, no, va teragenu is and you murmured, meaning in your tents. Okay, so Shimon ben Tarfon says, teragenu is interpreted as though it is composed of two Hebrew expressions. You explored, tartem, the land, and you disparaged, genitem, it, that is, in the tent of the omnipresent. With regard to the verse, as far as the great river, the river Euphrates, Deuteronomy 1, verse 7, Shimon ben Tarfon says, although it is not the longest river, the Euphrates is called great in accordance with the adage, draw close to the one anointed with oil and become anointed as well. Because the Euphrates is close to Eretz Yisrael, it is called great. The school of Rabbi Yishmael taught a similar idea. The servant of a king is like a king. The Mishnah teaches, and that just reminds you of Israel in general, where we all have tefillin, which are considered crowns. But anyway, and we're servants of Hashem, the King of Kings. All right. The Mishnah teaches that the storekeeper, relying on his ledger, takes an oath and receives payment. If an employer tells a storekeeper to pay his laborers, and the storekeeper claims he paid them, well, the laborers claim that they did not receive payment. Both the storekeeper and the laborers take oaths and receive payment from the employer. It is taught in a Braita. Rabbi Yehuda Hanasi said, why is there the brother with this oath? That it is imposed upon both of them. Rabbi Chia said to them, we learn in the Mishnah 45a that both of them take an oath and receive payment of their claims from the employer. The Gemara asks, did Rabbi Yehuda Hanasi accept from him that this is the halacha, or did he not accept it from him? Coming here, as it is taught in a Braita, Rabbi Yehuda Hanasi says, the laborers take an oath to the storekeeper that he had not paid them, and if it is so that Rabbi Yehuda Hanasi accepted Rabbi Chia's ruling, then Rabbi Yehuda Hanasi should have instead said that the laborers take an oath to the employer. So Rava said, do not conclude that Rabbi Yehuda Hanasi did not accept Rabbi Chia's ruling. Rather, interpret his statement as follows. The laborers take an oath to the employer in the presence of the storekeeper so that they will feel ashamed to lie with him present, since he knows whether or not he paid them. It was stated about a similar topic that if there were two sets of witnesses who contradict one another, and it is clear that one set must be testifying falsely, Rav Huna says this set can come by itself and testify about the other cases, and that set can come by itself and testify. Neither set of witnesses is disqualified for future testimony, since there is no way of knowing which was lying. Rav Chisda said, why do I need to become involved with lying witnesses? Since each set of witnesses is possibly untrustworthy, both sets are disqualified. The Gemara cites the circumstances relevant to this dispute. If after contradicting each other, the two sets of witnesses testified about circumstances involving two distinct lenders, the two distinct borrowers, and therefore two separate promissory notes, each one signed by a different set of witnesses, this sort of scenario is the subject of their dispute. According to Rav Huna, both promissory notes are valid, and according to Rav Chisda, neither is valid. In the case of a single lender and a single borrower and two promissory notes, with each signed by a different one of the sets of the witnesses, the holder of the promissory note is at a disadvantage and can collect only the lower sum. One of the promissory notes is necessarily not valid, as it is signed by witnesses who testified falsely. In a case of two lenders and a single borrower, the two promissory notes, this is the same as the Mishnah. So where two claimants who contradict each other come to collect payment from a single person who must pay them both, as the evidence for both claims has a presumptive validity. The case of two borrowers and a single lender and two promissory notes, what is the halacha? Can each of the borrowers claim that the promissory note supporting the claim against him is not valid, as it could have been signed by the untrustworthy set of witnesses, or does each of them have to pay unless he can prove that the promissory note against him was signed by the unfit set of witnesses? The Gemara states the question shall stand unresolved. And then last line here of Daf 47, Rav Huna bar Yehuda raises an objection from a Braita, and that is the end of Daf 47. Thanks for watching.